circumstances for the pandemic, my family could not be present today. Even though they are not here, I would like to recognize my wife of 21 years, Valerie, our 17-year-old son, Luke, and our 20-year-old daughter, Blakely, for fully supporting me and my career. Valerie has worked in education and more recently as a contractor working with the Small Business Administration. Our son, Luke, is a high school senior, and after he graduates in May, plans to continue his education at either Washburn University or the University of Kansas. Our daughter, Blakely, is currently attending Clemson University in South Carolina, where she'll graduate next May and then desires to go on to medical school after that. The opportunity for me to serve at a higher level would not have been possible without the unyielding love and support of my family. I want to take this opportunity to thank them for all they do and have done in supporting me and my career. So how did this get started? I'm the son of a proud 30-year United States Navy sailor and a Spanish mother. Because of my father's service and my mother's heritage, I spent much of my formative years in different countries, including Panama, Venezuela, and Spain, and gained an appreciation for cultures and practices that are distinct from our own. I am who I am because of the values my parents instilled in me and want to thank them for their guidance and support. My military career began when I was commissioned as an officer through the United States Air Force Academy in 1991. Following flight school in Texas, I was stationed at March Air Force Base, California, where I was a supply officer for 3 years. Getting back into flying, I was moved to the United Kingdom and then back stateside to McConnell Air Force Base, Kansas. I arrived in Kansas in November of 1998 and realized then that this was a place where I wanted to settle down and raise a family. I left active duty in August of 2001 in order to fly with the Air Force Reserve Unit at McConnell Air Force Base. In September of 2002, my flying experience provided me the opportunity to transition to the Fighting Jayhawks of the Kansas Air National Guard, and I took it. The unit was transitioning from the B-1B Lancer to the KC-135R Stratotanker and was in need of fully qualified instructor pilots like myself. In 2006, I stepped away from flying and stepped into the world of intelligence, surveillance, and reconnaissance. I've held myriad command positions within the 184th Wing at the lieutenant colonel level as well as the colonel level, to include commanding the wing itself from 2018 to 2020. Before taking command of the 184th, I had a great opportunity to work at Headquarters NORAD and United States Northern Command in Colorado Springs for 2 years. Today, I am privileged to serve as the Director of the Joint Staff for the Kansas National Guard. I have been serving in this capacity at the pleasure of our Adjutant General, Major General David Weissar, since April of 2020. Recently, I had the honor of leading a team of approximately 300 Kansas National Guardsmen to the District of Columbia to support the presidential inauguration. From working in logistics to flying combat aircraft in multiple campaigns to supporting joint and combined forces in hotspots across the globe with intelligence, surveillance, and reconnaissance, my career has been shaped by the willingness and opportunity to step outside of my comfort zone and lead in some new endeavors or mission sets. Each of these experiences has shaped me personally and professionally and prepared me for being a senior leader within our organization. This past year has been a busy one for the Kansas National Guard. Some missions included assisting with flood response, fighting wildfires, performing myriad operations in support of the COVID response, to include vaccinations, supporting the presidential inauguration, and most importantly, carrying out our federal missions overseas. I look forward to continuing to serve the men and women of the Kansas National Guard, the state of Kansas, and our nation. Thank you for your time, and I stand ready to answer any of your questions.
Are there any questions? Senator Faust Goodell.
Thank you, Mr. Chairman. Colonel, I think everybody who stands there deserves a question. So in your opening statement, I felt the emotion thereby you shared with us, sharing your story of your family. And I think when you stopped by my office, you said that they were still in Wichita and your wife would be joining you here. So will you be residing here in Topeka?
Absolutely.
How does that work?
Yes, ma'am. So thank you for the question. And so obviously, family is very important to me. And so yes, right now I'm a geo-batcher. So I live out of an apartment here where I get to do my daily job. And then just for the best for our family was I didn't want to lose the Father of the Year award for our son. And so we elected what would be best for us was to let them stay in Wichita where he could graduate from high school, move on to bigger and better things. And then I would just be forward deployed up here to Topeka. And I can't wait for graduation in May where we can get back together as a family again. So thank you for your question.
Mr. Chairman, if I may, Colonel, just to share, what is your most, out of everything, your impressive resume and the information the general shared, what do you think would be your most important duty within this confirmation?
So I think my most important duty in the position that I serve as the Director of the Joint Staff has nothing to do with the staff, but it's in providing my boss, the Adjutant General, with the best counsel I can on matters pertaining to Army and Air National Guard forces across the state. And so that's in addition to running the 11 divisions that make up the Joint Staff, but my primary job is to make sure that I am providing him with the best advice that I can.
Thank you. Is there any further questions? Yes, Senator Dietrich.
Thank you, Mr. Chair. I don't have a question, but I have a comment. I've known Colonel Veneri for a while because he's been our resource for Starbase. That's a program that we operate throughout Kansas that brings students to our military bases to be able to get some additional instruction and STEAM activities. So I fully support him and thank him for being here, and thank you all for your service.
And so I'll just take this opportunity to thank you. And so many of you may not know that Senator Dietrich serves on our board of directors for Kansas Starbase. And so that is a tremendous responsibility, and thank you very much for the participation in that and your continued service.
Any further questions? I want to say thank you very much. Do you have a question? Senator Longbine?
Mr. Chairman, if you would entertain it, I would like to make a motion to forward this proud airman to the full Senate for confirmation.
Motion's been made by Senator Longbine, seconded by Senator Peterson to bring this confirmation to the full Senate for confirmation by the full Senate. And so is there any further discussion on that motion? Seeing none, all in favor say aye. Aye. Opposed? Didn't think we'd have any, and we don't. Thank you very much. Thank you very much for being here today. We do want to say thank you for the service to our country. We definitely appreciate it. Thank you. Next item on our agenda is a hearing on Senate Bill 181, which is creating a Elevator Safety Act to require inspections of elevators and licensure for elevator installation and repair. So at this time, we'll ask our staff, Jason, to give us a update on this bill.
Thank you, Mr. Chairman, members of the committee. You have a memo summarizing Senate Bill 181 in your bill packet. This would create the Elevator Safety Act. The act would be implemented and administered by the state fire marshal. The act does two things primarily. First, it requires companies that are going to erect, construct, install, or dismantle elevators to be licensed elevator contractors under the act, licensed by the state fire marshal. And then any mechanic who is working on an elevator for a licensed contractor has to also be licensed as a licensed elevator mechanic under the bill. And then the bill also requires licensure for any individual who does inspections of elevators to ensure compliance with standards and codes. And all elevators that are inspected in the state, if the act goes into effect, would have to be inspected by a licensed elevator inspector. And so the bill, sections 7, 8, and 9 of the bill go through the licensure of those 3 licenses. There's application fees with amounts, maximum amounts set of $500 for contractor, $150 for a mechanic's license, and $250 for an inspector's license. Those are maximums. The state fire marshal can set a lower fee if that's all that's required to cover the costs of regulating and issuing those licenses. There is proof of general liability insurance coverage required for contractors and inspectors. The bill also allows the state fire marshal to issue temporary mechanics licenses if there is a emergency disaster in the state requiring more elevator mechanics than are currently licensed in the state. And so the state fire marshal can recognize that situation and issue temporary license mechanics licenses. And then there's also those are emergency elevator mechanics licenses. And then if a contractor needs more mechanics for a particular project or projects, they can petition the state fire marshal to issue temporary mechanics licenses to individuals who do not currently hold one to help achieve and accomplish that work. In addition to licensing companies and personnel, the bill also regulates elevators that are in operation in the state by requiring those elevators that are subject to the act to be registered with the state fire marshal. The bill defines elevators to be any device for lifting or moving people, cargo, or freight. The definition specifically excludes amusement rides, mining equipment, self-propelled vehicles like airplanes, boats, trains, trucks, boiler grate stokers, and any lifting device that's used in grain elevators or other grain, seed, and feed storage facilities. Section 3 of the bill also excludes from the scope any elevators that are under the control of the federal government or a federally recognized Native American tribe, any elevator that's within a single family residence, so private elevators in a private residence, and any elevator that's in a manufacturing, utility, or industrial facility, except wind turbine towers would be regulated by the act. So the act is really focusing on those commercial elevators in office buildings and commercial residential buildings, apartment buildings is what the bill is really targeting in terms of its scope. Before any new elevator can be constructed or installed, the contractor has to obtain a permit from the state fire marshal for that project. There's a permit fee not to exceed $400 for that. And then each elevator that is operated in the state that's subject to the act has to be inspected each year by a licensed elevator inspector. Elevators that are not subject to the act can be inspected at the discretion of the owner operator of the elevator. If they are, however, inspected, that inspection must be done by a licensed elevator inspector. And then the bill requires that when the elevator is to be registered with the state fire marshal, when it is issued a certificate of operation, which is a certificate that the elevator has passed inspection and is good to be operated in the state. There is a rollout for those. For those elevators that are in operation prior to the effective date of the bill, so that are currently operating up until July 1, the bill provides those owners with a year to apply and obtain a certificate of operation. The elevator can continue operating, but they have to get a certificate of operation and have it registered by July 1st of 2022. For those that are newly installed in the first 6 months, the bill is effective, so July 1 to next January 1, those elevator owners must obtain a certificate within 6 months after the elevator is put into operation. And then for any elevator that's newly installed or constructed after January 1 of 2022, the licensed contractor that did the installation has to obtain a certificate of operation before the elevator can be placed into service. The bill provides for investigations of allegations of violations of the act, or that any elevator appears to put the public in danger. There's provisions for a person to request an investigation of the state fire marshal to do that. There's also the usual provisions for the fire marshal to suspend or deny licenses for violations of the act, or impose civil penalties of up to $1,000 for a violation of the act. And then finally, there's a rather extensive rule and reg authority for the state fire marshal for implementing and administering the act. And the bill establishes an 11-member elevator safety advisory board to assist the state fire marshal in reviewing and adopting rules and regulations for the act. As I said before, the bill will go into effect July 1st of this year if it's enacted. I'd be happy to answer any questions, Mr. Chairman.
Thank you, Jason. Is there any questions for the provisor? Seeing none, we'll move on to the proponents. And because we have an extensive list of proponents, neutral, and opponents, we'll wait to do the questioning until after all the proponents, and then we'll do the neutrals and the opponents. We do have written testimony from, I think, 3 people. So make sure you see that in your packet. So we'll move to the proponents. And the first proponent would be Mr. John Federico on behalf of the Elevator Industry Work Preservation Fund. Good morning.
That's just cruel. All kidding aside, John Federico with Federico Durst Consulting. And yes, I appear in support of Senate Bill 181 on behalf of the Elevator Industry Work Preservation Fund. Basically, in its barest form, the people that work on these elevators. You'll also hear after me testimony from the National Elevator Industry, the NEII, essentially the folks that install them. And what's significant about that is that with the support of and in conjunction with the entire elevator industry, we are asking you as policymakers to support legislation that would take simple steps to establish uniform state standards that would benefit both the industry and the general public. My testimony will be very short as to leave time for Ms. Wisman and Ms. Chaney, who will offer relevant testimony. But I did want to take the opportunity to emphasize the collective effort that has been made to shape this bill into something that is wholly reasonable, in our opinion, while still trying to achieve the goal of establishing a framework for basic elevator safety. We have to start with the bare facts. Currently, Kansas has no statewide requirement in place that requires for the inspection of elevators. Kansas currently has no statewide requirement that people who install, maintain, or conveyances be trained or licensed. And it struck me as odd when we first started having conversations of this. And we're not breaking new ground. There are a lot of examples to use, but the Kansas State Legislature thought it important enough to establish the Kansas Boiler Safety Act that requires inspections and that people show certification of training to install those, which carry no people. Ms. Wisman will elaborate on how Kansas is significantly lagging behind other states in the oversight of elevator safety standards, regulation, inspection, and compliance, which is really at the heart of Senate Bill 181. including the fact that we are only one of 2 states that have not adopted basic safety codes for elevators. I've been around a while. I understand whenever you introduce legislation that, at least on its face, appears to increase regulation, grow government, add costs, you better make your case why that's important. And I think, and I hope by the end of our testimony, you'll see that the growth in government will result in potentially 2 FTEs. The increase in cost to the state budget, this should be revenue neutral. As far as adding cost to the end user, owners of buildings with elevators, that will be addressed later. And we would ask you the minimal cost that we would be asking people to share versus the number of people that are using that equipment every day. And we'll let policymakers decide. This issue has been taken up before, going back to an overly onerous bill. Several years ago, a bill was drafted. I don't believe it even had a hearing, but I can tell you our firm, sitting down with the client and the industry, took a lot of time to make this better. And we removed from that other piece of legislation nearly 300 lines and 7 pages from that bill. And so when I tell you we believe this is reasonable, I say that sincerely. We visited with over 15 different groups that would have an interest in this, working towards a compromise. Some we were successful, I'd say most we were successful, but we were willing to listen. Towards that end, we reached out to the wind industry just this week and have conceded that they should be exempted from the provisions of Senate Bill 181. My proposed amendment, approved by the wind industry, is attached to my testimony, and if we need to get something different to the reviser and to Connie, we will certainly do that. In closing, I sincerely appreciate, with the busy schedule, the opportunity to present. I guess I also hope you appreciate the enormity of the effort that was made to try to present a bill that's acceptable to you. And at the end of the day, we hope you appreciate that this is mutually beneficial to the general public and to the industry as it relates to safety. I would ask for your favorable consideration of 181 and would stand for questions at the appropriate time.
Thank you very much. We'll ask the questions after the proponents. The next proponent is Katie Wisman on behalf of the Elevator Industry Work Preservation Fund. Katie, welcome.
Good morning, Mr. Chairman, members of the committee. Katie Wisman with Federico Durst Consulting, again, also on behalf of the Elevator Industry Work Preservation Fund. I'm happy to appear in support of 181 today. You know, as John mentioned, this does present a stark contrast to where we have been before. So I'll go into that in a little bit more detail towards the end of my testimony. But you know, this bill really is about safety. Like many other professions in the construction field, elevator inspection, installation, and maintenance does pose a risk to those working on the job that can be injured or hurt if those things are not maintained properly. And much like you and I riding on elevators, unmaintained elevators do pose or can pose a risk to the general public, as well as the mechanics who work on that very complex equipment. As John mentioned, we are just one of a handful of states that has not adopted code. In fact, Kansas is one of only 2 states with no safety requirement for the inspection of elevators through that national code, and is one of only 14 that does not require licensure of the individuals who install, maintain, or inspect the elevators. I've provided a map attached to my testimony, and as you can see, we are surrounded by states that require both inspections and licensure. So Senate Bill 181 seeks to remedy that. And the main purpose of this piece of legislation is really twofold. One, ensuring that we have a statewide standard for the maintenance and inspection of elevators. And two, ensuring that everyone that installs, maintains, and inspects them has the proper training and education to ensure that they are safe and the public is safe. As John mentioned, Senate Bill 181 is the result of compromise and reason. When compared to some of the previous versions of this bill, we have exempted single-family residences as well as industries that are highly regulated or have elevators that are highly restricted in accessibility. We have eliminated a previous unfunded mandate that would have required the counties or cities to conduct the inspections and have instead created the opportunity for third-party inspections. We eliminated previous state preemption issues. We have removed the previous requirement that would have required those applying for licensure to undergo criminal history record checks. We didn't feel like that was a reasonable requirement. So that has been taken out, and we've also eliminated the criminal penalty for noncompliance. So what we have is a common sense policy. Like required by many other professions that affect worker safety and health or public safety and health, this does require licensure, as I mentioned, of the contractors who install, the mechanics who maintain, and the inspectors who oversee the annual test. It also requires the annual safety inspections. Now, I want to point out that if a building owner or state government, for example, already has an existing maintenance contract with an elevator company, the costs of the inspection will be included in that existing maintenance agreement. For those building owners that don't have a contract, the costs are, what we perceive to be a minimal investment by that building owner to prevent accidents in their building. John also mentioned it is revenue neutral. The actual fees that will be assessed, the fire marshal will talk a little bit more about this, those fees will be set in regulation, but we anticipate them to be far less than the caps that we have put in the statute. We created statutory caps to allow the flexibility for those fees to be raised or lowered and only offset the costs of administering the implementation and oversight and enforcement of the program. Also, this doesn't excessively grow government. Unlike some other states that require all the inspections to be done by the state, we're not asking for a number of FTEs to be added to the fire marshal's office to do that. It will just be the administrative oversight and enforcement, and then the third-party inspectors will be the ones that will be licensed and conducting the required inspections. It also, as Jason mentioned, provides a phased-in approach for both the registration and inspection, so it allows the fire marshal and building owners ample time to comply with the provisions of the Act. And lastly, we believe it strikes middle ground between law and regulation by providing enough statutory direction to the fire marshal while allowing them to oversee the day-to-day of the implementation and enforcement. With that, we would seek your support of Senate Bill 181. Again, we believe this is a common sense policy that allows the state of Kansas to take simple steps toward ensuring the safety of those in the industry as well as the general public. I would be happy to stand for questions at the appropriate time.
Thank you very much. Moving on, we've got next proponent would be Chelsea Chaney, Director of Government Affairs for National Elevator Industry. Chelsea, good morning.
Good morning. Thank you, Mr. Chairman and members of the committee. My name is Chelsea Chaney, and I am the Director of Government Affairs for the National Elevator Industry Incorporated, or as we like to reference it as NEI. In this capacity, I manage legislative and regulatory issues and activities across the country. I'm a Kansan, and I grew up in Independence, and I currently live in Leawood. However, it is interesting to note that NEI is actually headquartered right here in Topeka. It is really nice to see some familiar faces today. I recognize a lot of you. I've had the opportunity to work alongside many of you through my previous position working for Senator Pat Roberts for many years. So it's nice to see some friendly faces this morning. The National Elevator Industry is a trade association that represents the largest manufacturers of building transportation in the United States. Our members represent more than 85% of the industry work hours nationwide. Some of our companies I work with who also operate here in Kansas are Kone, Otis, Schindler, ThyssenKrupp, and MEI Total Elevator Solutions. I sincerely appreciate the opportunity to speak here today in support of Senate Bill 181. This legislation may look familiar to some of you, as my organization last appeared in front of the Kansas Legislature supporting similar legislation in 2016. We are pleased to report, as my colleagues have mentioned, that under this legislation has gone through overhaul and has really reduced and refined the message that we're trying to tailor. With that, elevators, escalators, and moving walkways are a necessary means of transportation to ensure accessibility for all. As an industry, it is our #1 priority to ensure the riding public, as well as the men and women who work on this complex equipment, are safe. The most effective way of ensuring the safety of the riding public, as well as elevator personnel, is by adopting the most recent version of the National Model Safety Code for elevators and escalators. In Kansas, the current responsibility for adoption and enforcement of construction codes lies within local jurisdictions, unless, of course, it's a state building. To date, Kansas is one of 2 states that has not adopted a statewide safety code for elevators and escalators. This inaction has created a hodgepodge, crazy quilt of codes and standards across the state, including inconsistent licensing requirements and a wide array of inspection protocols. These inconsistencies are challenging and they're burdensome for elevator companies who wish to operate in our state. At NEI, we like to say we put standards in motion. 48 states have adopted statewide standards for building transportation, but Kansas isn't one of them. In fact, our state remains at the bottom of the list for providing an adequate level of public safety. This legislation provides the solution by requiring that the state fire marshal adopt regulations that include the most current edition of the code. Senate Bill 181 will create an elevator board comprised of 11 Kansans who are committed to public safety and possess industry expertise. An elevator board is a valuable tool to assist in the oversight, regulation, and enforcement of this very specialized industry. Currently, 38 states have an elevator board advisory committee, and all of those operate under the jurisdiction of a state agency and provide this really valuable technical support to those states that currently enact those. For Kansas, this advisory board will help the state create this new program, drawing from experience they've gained through industry involvement. The board will meet annually to review any regulations adopted by the state fire marshal. Nationally, all but 14 states have adopted elevator mechanic licensing requirements. Licensing program establishes a minimum set of standards for qualifications, education, and training for the men and women who work on this highly complex and very technical equipment. Most jurisdictions in Kansas have no minimum standards for technicians who work on these machines. Both the riding public and industry personnel should be able to trust that people installing, maintaining, and inspecting building transportation equipment have demonstrated a fundamental competency and undertake continuing education. Careers in the elevator industry are highly paid jobs with exceptional benefits for workers who possess a mechanical aptitude. Many elevator companies bid on work across state lines so they can keep their workforce employed and active. Currently, Kansas contractors and mechanics must obtain licenses to do any work for any of our bordering states. Once Senate Bill 181 is passed, industry personnel licensed in Kansas would have reciprocity and be able to obtain licenses in other states more efficiently and effectively. Kansas contractors would be able to reposition personnel as needed and work on out-of-state projects without unnecessary licensing delays. Now, more than ever, identifying opportunities for Kansans to find reliable employment is critical. The cost of creating and managing this new elevator program should be revenue neutral. From NEI's experience engaging with elevator programs across the country, most, if not all, elevator programs nationally are revenue neutral or operate with a slight excess in funds. And we expect nothing less than or different in Kansas. So I must admit, it is unusual for an industry to actively seek regulation, which should be a testament to how critical Senate Bill 181 is for public safety and reliability. Both contractors and workforce have agreed to these cost-based fees and consider them to be an appropriate investment to develop a program that ultimately increases elevator safety for the riding public and industry personnel. NEI's member companies and our mechanics are both willing to pay fees that cover the program costs in order to ensure a minimum level of safety to protect both the riding public and elevator industry workers in the state of Kansas. There are approximately 10,000 elevators and escalators in our state, and much like planes, trains, and buses, building transportation is public transportation and should receive a minimum safety standard for the riding public and industry workers. It's difficult to argue about public safety, which I'm sure we can all agree on. And it is certainly my hope that with your support, Senate Bill 181 will create a more safe Kansas for everyone. Thank you for your time, and I'm happy to stand for questions when appropriate.
Thank you very much, Chelsea. Are there any questions for any of the proponents that are up there today? Yes, Senator Faust.
Thank you, Mr. Chairman. Thank you, Senator. John Federico, in your testimony, you've got an amendment in there, that a balloon amendment. Is it already in the bill? Has it been agreed upon with both sides? Where are you?
Yeah,
Speak on that, please.
it is in agreement with the wind industry to exempt them out. The purpose of it is to exempt them out. It's not been presented to the reviser for official adoption. It's presented to the committee for your consideration, but we are fully in support of exempting them out, and they have they've looked at the language and approved it.
Senator Peterson.
Thank you, Mr. Chairman. I don't know if this will be for NEI or John. Anyone can answer it. We noticed that a lot of the states are not adopting the codes when they first come out. I know in the electrical business, a lot of codes are a year delayed before they adopt them after they've done, so private industry can catch up. This requires them initially to adopt the latest standards, but moving forward, does it give the state fire marshal a leeway to where he doesn't have to adopt the most current? He can wait a year until the private industry is caught up?
Thank you for the question. This bill, as Jason mentioned, does require the fire marshal to convene that advisory board of subject matter and industry experts and professionals to help with the promulgation of the rules and regs. We don't want to reinvent the wheel, so to speak. And it also requires them to be brought together on an annual basis to review Kansas regulations and safety standards as compared to those and any changes that would have been proposed nationally to the code, and then leave it up to them to balance the update with the industry.
Thank you.
You're welcome.
Any further questions? Yes, Senator Coles.
Yes, a question for John. Actually got a couple if that's okay. So currently there's no annual inspection required for like in hotels, apartments. Am I understanding that right?
No statewide requirement.
Statewide.
It's a county by county, city by city
Okay.
option.
And then what is the tag that you normally see in an elevator that says this has been inspected?
That would suggest that, and Katie might be best to answer this, but that would tell you that that elevator has been inspected, and they are to display that certificate to prove that it's been inspected.
But on a state level, it's not required.
Correct. And it's the fact that Shawnee County might require it. Douglas County doesn't. Johnson County has a set of standards. Sedgwick County has, it's very problematic for the industry. It seems like it is a worthwhile endeavor to set up some very simple protocols and requirements and standards that would apply statewide. Again, our goal is to not make them overly burdensome or expensive, but that uniformity is going to help this industry tremendously.
Mr. Chair, can I, one more statement? I'm not big on more regulations, but this hits home personally. I have a 2-year-old grandson that actually lives here in town, and his mother was taking him on an elevator, pushed the button, the elevator opened, and it was just empty. The door opened. Thankfully, she had her hand on him. 2 years later, he was at a hotel, and the elevator door slammed on his arm and almost broke his arm because it had so much pressure. So it wasn't designed or tested evidently for, a young child like that. And so, I mean, this hits home. I'm kind of surprised that there isn't some type of a state, like you're saying, mandate on this. And I would be in support of something along these lines. Thank you.
Any further questions? I do have one. We have heard during your testimony, and all three of you have said the term writing public. The question that I have is under B, under section 2, we're saying that these items are also covered, and that's a dumbwaiter, a conveyor, chain or bucket hoist, construction hoist, or similar device used for primary purpose of elevating or lowering materials. I don't believe that writing public is included in that statement.
If that was a question, I'm happy to provide an answer or
That was,
response.
yes.
So in visiting with the industry, just to better understand the distinction there, I now understand that all of those provisions that are in the subsection you referenced are part of the current American national standards known as the American Society of Engineers Safety Code for Elevators and Escalators. And the bill requires that the fire marshal adopt that national standard as a minimum, is what we're recommending. So, the industry considers dumbwaiters to be small elevators, and they also have complex mechanical systems that pose a risk to the untrained worker that is interacting with those systems. They shared with me actually that there was a woman killed in a grocery store on a dumbwaiter in New York City just within the last 3 months. So they are as dangerous as elevators, even though they're transporting materials and not people.
They probably are not licensed for public transportation. Would that be true? So the lady probably wasn't in there following the regulations.
I don't have specifics on how she was killed. If she was riding it, I don't know. But if you would need additional detail, I could get it for you.
Okay. And then would this building here be covered under your bill?
Yes, this building would be covered under the requirements of the provisions of the Act.
It does say in there, any federal building, it does not say state-owned facilities.
Correct.
So, okay.
And I do know, just doing some research leading up to the hearing, I went to the state procurement website, and there are a number of state agencies that had already put out a competitive bid RFP for a maintenance contract agreement with, some of the larger companies. So a number of state agencies already have maintenance agreements. And as I mentioned, the cost of the inspection would be borne by that existing agreement.
Thank you very much. And then further questions? Yes, Senator Ware.
Thank you, Mr. Chair. I'm wondering, and maybe I missed something in the reading here, about commercial elevators, the freight elevator in the factory. That carries freight, but it also carries people. Will that be included in all of this?
That might be a more appropriate technical question for Jason, but I believe if you look at page 2, let me find it here. Starting on line 20, those within manufacturing, utility, or other industrial facilities would be exempt. And then the reason for that is that most of those large facilities are already significantly regulated and comply with OSHA. And our understanding is that OSHA is, considers the national code in their standards.
Any further questions? Seeing none, we'll move on to the, we have neutral. And the first is Mr. Josh Cevadi with the Kansas Advanced Power Alliance. Welcome, Josh.
Morning, Mr. Chairman, members of the committee. Thank you for having me. I am Joshua Cevadi, speaking on behalf of the Advanced Power Alliance. Incidentally, this is the very first time I have ever spoken on behalf of the Advanced Power Alliance. I am, as you all know, the B team. My wife, Kimberly, normally handles these things. But as John Federico suggested, we are here neutral because we have agreed to language. Everyone agrees to it. We are fine with it. If I can't help deliver this language, it is possible you will never ever see me again. So this is a simple fix that we're asking on behalf of this. But we just want to be included in the exemptions in large part, as you can see in my testimony, for 3 reasons. First, we are not open to the public. Wind towers are sealed off and locked. Second, and on top of that, the only people that can climb them are our certified wind turbine technicians, many of whom were trained in Cloud County Community College. And one of the things they learned there is how to safely climb those towers. Second, we don't have elevators as you would think of them as elevators in the towers. They are ladders. There are lift hoists there to bring equipment up alongside them, and then what some of us would call a daisy chain or a lift assist to make sure that if you fall on the ladder that you don't come back down. But those are all, as you see in the third point that I make, inspected at the point at which they are, the manufacturer puts them in place, and then each of our technicians that climbs is trained in whatever program they are in to do an inspection of that before they use it anyway. So for those reasons, everybody agreed to the language again, and we would come in as neutral, provided that that balloon language is included. Thank you.
Thank you. Next one we have for neutral would be Randy Stokes from the Senior Vice President of Government Affairs, Kansas Grain and Feed. Welcome, Randy.
Thank you, Mr. Chairman. I know we're close on time, so it's kind of already been stated by both Mr. Cevadi and Katie about why the grain industry is specifically and intentionally exempt from the language of this bill. Now, it's been stated that this bill in some form has been brought forward since 2016 a few different times. In those instances, we did oppose. We opposed because we were not excluded from the bill. It's important to know that the grain industry is regulated in this instance in our grain elevators. In other words, the nomenclature is problematic because we're talking about elevators and we're the grain elevators. Well, yes, the elevators and conveyance systems within our facilities do lift the grain. There's also man lifts and other conveyance systems within our facilities. But the important point to take away is a few things. One is that we are heavily regulated by OSHA in all facets. Now, the conveyance systems within our facilities are inspected by OSHA annually, and they're inspected against a federal standard, the ASME, and those are set forward in my written testimony that you've got, so you can check that. But to be clear, our facilities are inspected annually by OSHA. In fact, we're in a local emphasized program within OSHA, even in our specific industry. So we're even in enhanced inspection protocols for our grain industry. Secondly, also you'll see in my testimony that the other states surrounding us that have adopted this type of inspection protocol for commercial elevators have exempted our industry, the grain elevator industry. It's been exempt within, I believe it's Missouri, Oklahoma, Colorado. So this isn't new to exempt our industry. And then finally, there was another point. So our elevator, just like the wind turbines, our elevators are generally accessible to the general public. You know, there may be a rare instance where they are, but these are not regularly accessible to the general public. These are within our facilities for industrial purposes, and for that reason, we stand neutral on the bill today. But if, for whatever reason, we were removed to be exempt from the bill, we would have to oppose the bill. So we appreciate your letting us come here today. I know we were short on time, but thank you for the.
Thank you very much, Andy. Next, we have the State Fire Marshal, Doug Jorgensen. Welcome.
Thank you, Mr. Chair, Committee, for the ability to appear before you today with neutral and informational testimony. Basically, I'll just, because of the time, go into some of the costs that we see coming forward for our agency. We look to probably have to hire 3 staff to administer this program. One of those would be temporary, and we would probably only need for the first year. And most of that would be for all the data input. Once we start receiving all the information on what was 13,000, but taking off the wind turbines, we're down to about 10,000 elevators, escalators in the state. The cost of that for the first year would be about $190,000. After that, it would drop a little bit because there'd be one-time expenses the first year that wouldn't be in the second year. So we look at our expenses going forward to be in the $170,000 range, possibly after the first year. Since this bill also establishes the elevator fee fund, where any fees that we collect would go into, but since we'll be starting with a zero balance there, in my fiscal note, we had asked about possibly SGF funding for the first 6 months, but in reflection and in conversation with staff, we'd be able to sort of do a loan probably out of our boiler fee fund to take care of those costs. And then as we started getting the fees and things in from the industry, we'd pay that loan back. So we're not looking at any SGF funding needed to get started. So that's basically a breakdown of our expenses. It allows for license fees to be collected, and has already been testified to. They've been set fairly high, but for our office looking forward, and it's just, again, preliminary, but we look at all those fees probably being in the $25 to $50 range versus the $100 to $400 range, just to help mostly with the facilities and reduce their costs for the inspections and things. Salaries, benefits, if we did set the fees at the current maximums that are in the bill, I think we would take in a little bit over $1 million, which is definitely not necessary. So that's why we're looking at reducing those fees. And again, it's been discussed with the exclusion of wind turbines. We are about 10,000 units. Estimates from the industry, there are about 49 contractors in the state, 31 inspectors. Mechanics, there are 440 mechanics in the state. So again, the income from that will be sufficient for our agency to move forward with administering the program. And with that, I'll stand for questions at the appropriate time.
Thank you very much. Is there any questions for any of the neutral? Yes, Senator Faust.
Thank you, Mr. Chairman. My question is for Joshua Cevadi. Josh, you and I served together in the House of Representatives. You ran for governor. I think you were the Secretary of Ag. And you used to talk about this kind of stuff years ago when we served in the House. So as a neutral conferee, as John Federico and others have mentioned, so there's no statewide requirement. So how would this logistically work, though? So we always say home rule of local home rule and how in the need of a urban versus rural area. So what kind of standards could actually be put in place to whereas it still respected that local ordinance and then required the statewide piece for safety?
So, thank you, Senator. I think you were asking me to sort of take off my hat as an advocate for the renewable energy industry a bit and speak to this. And the only thing that I can say, I really don't know that much about the difference between the two. We did generally, when I ran a state agency, we had to stop doing hotel inspections, and it went to a request only. I mean, if you had a bad stay at a hotel, you could have a hotline that you could call, but they were not annually inspected. I would say as a general rule, that is less preferable to a situation where you knew that you had those entities being inspected. But that is, I don't want to wade into this at all outside of the realm in which I'm here to advocate. So, does that make? Did I accurately?
Completely tanked the bill.
Yes.
Mr. Chairman, with your permission, very briefly, it doesn't speak to home rule, but I thought it was worth mentioning. The city of Wichita, along with the county, they have a very robust inspection program. Those are the ones, we're trying to work with them to figure out if they're good, if they're as good as what you're requiring in this bill or better, then we need to find out a way to make sure that they can opt out or keep doing what they're doing. At the end of the day, if it's keeping people safe, if it's keeping our workers safe, then we're all about it. So we're trying to work with them, but to a certain extent, some communities do this and they do it very well. We'd like to preserve that somehow and continue to work with them.
Any further discussion from the neutral? We do have two written neutral that are in your packet. Let's move on to the opponents. We got Mr. Craig Jones, the owner-operator of the Country Home Elevator and Stair Lift. Mr. Jones, welcome to committee.
Thank you, Chairman. Thank you, committee. I come today just as a business owner. Unfortunately, I'm not a lobbyist or spokesperson. I come to this committee with just being a business owner and knowing that the impact of safety in my industry is critical and important. Again, my name is Craig Jones. I'm the owner-operator of Country Home Elevator. Founded the company in 2000. I've been doing business in Kansas for 20 years. My background is in engineering and design of elevator systems for commercial and residential applications. We do sell and install commercial elevators and residential elevators also. I hold a CETS designation from the National Association of Elevator Contractors. That means I am a certified trainer for my mechanics and team members. All my guys go through the apprenticeship program that we have and established, so all my guys are trained in that way. I've served on the NAEC, National Association of Elevator Contractors Executive Board, as the secretary for that organization. Provided training in CEUs for elevator mechanics and elevator inspectors through the NASA organization, which is a national inspection organization. I enjoy that. I appreciate the opportunities to train other fellow mechanics and inspectors. I've been a committee member on the ASME A17.1 committee. Does the actual writing of elevator code. American Society of Mechanical Engineers writes the elevator code, and that currently is the standard that anyone installing a piece of equipment in the United States would be held to as a standard. That really is what governs and keeps us on track with doing things safely. ASME is the governing body. If you go to court and you're in court for a issue, there's been an elevator accident, that will be the standard we would be held to as ASME 17.1. So I'm very familiar with how that code is written and have actually done written interpretations on that code that have come to my committee. I'm a licensed commercial elevator mechanic and contractor in Missouri, Arkansas, and Oklahoma. And so I'm very familiar with the trade, been in the business since 1988. I come today to testify on Senate Bill 81 in opposition of creating an additional rule, regulation, and something that creates an additional barrier to my business. My business is, our industry is the safest industry for transporting people. If you look in any type of headlines today, you will not find hundreds of issues with resident or with commercial elevators that they are unsafe or have had accidents. There are occasions that those happen, but because we're regulated on our own through our insurance company and through following ASME requirements, we are the safest industry to move. You can't move anything other, even on a car or sidewalk or walking up and down stairs, any safer than you can in commercial elevators. Normally legislation is brought through for some reason, and I've been unable to identify the current safety hazard for this. Obviously, other states have promulgated rules and have rules, but there aren't any current things that I've seen that say, today we must act because people are being injured or there's a problem with the elevator industry, because we are currently quite self-regulated. We do our own internal training and we do our own third-party inspections. We take care of getting all those done on commercial applications. Just want to know if the committee had considered the budget constraints starting a new code regulation, because they've mentioned 2 FTEs. I know that most jurisdictions, whether it's a city or a state, have far more than 2 FTEs to manage any type of elevator safety operation. Most are about 10 to 20 people to manage any type of elevator safety regulation. Has the committee considered the additional cost of business from a permit and inspection requirement? Yeah, it's a small fee to pay for a permit. It's a small fee to pay for an annual, but what happens to that mandatory requirement for permit and inspection means that there's additional mandatory work that's done. The concept of work preservation, the name of the organization is work preservation because it's out there to preserve work for the elevator industry. That's how I view it. Maybe not their concept. Has a committee considered, or are they aware that Topeka, Wichita, and the Kansas City area typically do third-party inspections? Wichita, I'm licensed in Wichita and Sedgwick County and Topeka, and we do inspections through those as well as any other areas. We also offer those, and in most of the Kansas City jurisdictions are already required to do third-party inspections. So it is already currently in most major jurisdictions. Legislation will put some small churches and nonprofits in a difficult position with adding additional liability and additional expense to their making their facilities accessible, to add additional permits and inspections. It's as it is, retaining the qualified mechanics is already a difficult enough job for me. I have to train and hire people who take 4 years to get a license in most areas. Adding one more requirement for me to submit another set of paperwork to another state adds another layer of difficulty for a business. Not that it's, it's just an additional layer of cost doing business. There is probably a much simpler process, simply to register elevators, provide proof of third-party inspection, require the contractor as a contractor to be licensed, and an inspector or inspector to be licensed, not mechanics, and only an initial acceptance test. The national ASME standard already requires annual testing, so ASME is the standard. It already requires for an annual inspection on elevators, as well as monthly maintenance and monthly requirements for checking things. The addition of a regulatory body only complicates and increases the cost of buildings owners and small churches. They're already struggling at this point to get things done and keep things open and going. I do not, again, believe that the 2 full-time employees will be full enough to make that operate. This will be additionally potential for a little bit more of a labor regulatory control. in most states, and I at least applaud the folks who have created this. They have pulled out some of what was originally in most of the other states that were mandatory ratios of employees that cause additional lack of me being able to employ a mechanic and train 2 people at once versus just a 1-to-1 ratio. So there are some issues with ratio that come in that will probably be in the regulatory process. When you look at that side of it, that really is normally how things are done, that you get a lot more of a complete bill ahead of time versus letting the regulatory really create the whole law. All I ask for you today is to really carefully consider the addition of the regulation and the cost to small churches and businesses, and possibly ask a few more questions before you vote on something that's maybe not fully developed. Thank you for your time.
Thank you very much. We have one more opponent, Mr. Christopher Landrum, and from the Director of the Wichita-Sedgwick County Metropolitan Area Building and Construction Department, and he is remote. And Chris, are you on the line?
I am, Mr. Chairman, and thank you. Thank you, Senators, for the time. As said, Chris Labrum, I'm the Director of the Metropolitan Area Building and Construction Department. We're the joint department for code enforcement, Sedgwick County and the City of Wichita. I want to state as we begin that I greatly appreciate the discussion that has been had today. And I do appreciate Mr. Federico's remarks about our program here. I want to make it clear that we do not oppose a statewide minimum safety standard. We are always in support of such. Our opposition comes from the fact that, as he indicated, we do have a very robust program here in place now. We're concerned what this would mean for us in that program, given the way it is currently written. So we utilize 3 of the ASME standards that have been discussed. One of those is specific to the repair or modernization of existing elevators, those especially that were put in place prior to code being very robust. Then there's the core elevator code, and also one that governs platform lifts and stairway lifts, excuse me. So we are currently on the 2016 version of the elevator code, and we're working to adopt the 2019. So had we not been interrupted by COVID for the better part of 2020, we would be as up to date as possible with our standards. We have more than 1,600 registered elevators and conveyances in our jurisdiction. About 95% of those are in the City of Wichita. Last year, we did 191 permits covering new installations, repairs, or modernizations. We licensed 15 contractors, 65 certifications for 65 of their on-staff mechanics, and we employ 3 full-time employees solely as elevator inspectors. They benefit from the fact that there are 6 other electricians and a supervisor who are able to assist them in the duties that they do when required, and they have a 11-person administrative staff of permit writers who are able to assist them with the administrative portion of their job, as well as IT and other support. So we're obviously very concerned about the amount of turnover that would take place, specifically Section 4 of the bill not allowing us an opt-out, as again has been pointed out. And then Section 5 appears that it would also prohibit our ability to control the local licensing of the contractors. If that was to go to the state, my main concern there would be a loss of revenue as ability to manage my program. As it stands now, our revenue is in the neighborhood of $250,000 a year, and it does just pay for the program. So with all of that, I mean, I wanted to still give the breakdown of the basics of our program so you would know that, but also probably don't need to take a lot more time. You have my written comments, and it's safe to say that if we were able to accomplish what Mr. Federico stated and give us an option to opt out of this based on our existing program, we would move to neutral.
Thank you very much. Is there any questions for Christopher? Are there any questions for Mr. Jones? We do have Mr. Brandon Ray has submitted written opposition. Are there any other questions concerning the hearing today? I appreciate the indulgence of the committee being a little late today running, but we did get through this and we got a lot of good information. And if there's no other questions, we are going to close the hearing. Thank you very much.